The appeal in the name of Burnford and others and AA Development Ltd.
Yes, Mr. Old.
May it please you, my lords and my lady. As you will have seen, I appear for the appellants.
Yes.
With Mr. Krishna Prasad, and my learned friends, Mr. Thompson and Mr. Griffiths,
Yes.
appear for the defendant respondent.
I can tell you that we have read the judge's judgment, we have read the certain arguments and the amended particulars of claim. We have also read the judgments of Lords Reed and Hodge in Marek, and the advice of the Privy Council in Primio, if that's how you pronounce it.
Yes. Lord, that's very helpful. I'll take the court to those cases, but can do it hopefully quickly and just refer to the particular passages that we rely upon. So you'll have seen that this is an appeal against an order of His Honour Judge Paul Matthews, dated 28th of February 2022. He didn't give permission to appeal. Your Lordship did. There are 3 grounds of appeal. The first is essentially procedural, that it's an evolving area of law and raises fact-sensitive issues, and I accept that that ground's probably better dealt with after I've dealt with the second, which is the rule in prudential. And you'll have seen there's a third ground relating to Mr. Asplin and the settlement of his employment claim. So that's the overall shape of the appeal. It's agreed that, as it was below, that the case is at this stage, the strikeout stage, being determined on the basis of the pleaded facts as set out in the amended pleading. In any event, the evidence that was before the judge and is before you is simply or witness statements from solicitors for each party. So there is no fact, no evidence of fact has been before the court at all. So, my Lord, I was going to go first, if I may, to our amended particulars of claim and go, I hope, briefly but effectively through what this claim is about. And you'll find that in tab 9 in the core bundle.
Yes.
Its status, my Lord, as you will have seen, is that we don't have permission for the amendments, but the matter proceeded before the judge on the basis that this was our case. But the formal application hasn't either been made or allowed at the moment. Now, my Lord, firstly, the parties, as the court knows, I represent all 5 claimants. The essential masterminds behind the business we're concerned with, Motoriety, were Miss Burnford and Mr. Astley, who are the first 2 claimants and appellants, and Messrs. Fitzpatrick, Simons and Gaskell were shareholders, all from the outset, and you'll have seen from the claims when we come to them that they all made initial investments to support the venture when it started.
This is before AAD came on the scene.
Yes, it is. Yes.
Is that quite right? I thought Mr. Fitzpatrick, Mr. Simons and Mr. Gaskell came in a bit later, but still before January 2015.
Oh, slightly later, yes, your Lordship's right. Yes, that's right. And in any event, Miss Burnford and Mr. Astley, my Lord, were directors of the company. And as you'll see when we get to the investment agreement, the shareholders agreement, that they're described as managers in that document because they were responsible for the day-to-day management. We identify the various AA companies and the individuals who were involved in the relevant events through to the rest of paragraph 1. And there's then a lengthy and detailed background section setting out first the starting point for all this, which is, as it's described in 2.1, in early 2015, the claimants wished to develop and expand Motoriety's business by finding a suitable investment partner enabling expansion of the
And there were
company.
two potential partners. One was AA, the other one was Solera. You say that AA made various representations which turned out to be false and which were fraudulently made, and they were in breach of their investment agreement, and if they hadn't made the representations, you'd have done the deal with Solera, not the AA.
Yes, my lord. Yes, my lord, that's a very speed dial and a very accurate summary. So just in relation to the facts themselves, could I just draw your attention, without going through the details, I know your lordship won't find that helpful, to the fact that these negotiations are being conducted principally by, but not entirely by, Miss Burnford and Mr. Asplin, on behalf of themselves, obviously, and on behalf of the other shareholders, as well as on behalf, to the extent necessary, of Motoriety, the company. And throughout the discussions, one of the matters, as we say, for example, in 2.3.3, throughout the discussions, AA Developments claimed that the principal benefits for Motoriety and the claimants were, and we then set out the background which led to the various representations which are described in the next section. But it's important, my lord, in my submission to note that the claimants, the shareholders, are conducting these negotiations as shareholders with a view to concluding an investment agreement, which we'll come to, between them and the AA, to which the company was also, as is often the case, a party. And as your lordship rightly said, we can turn the pages through paragraph 2, just stopping, if you'd be so good, at 2.11.
2.11.
2.11 on bundle page 115.
Yeah.
You'll see we plead there that following a meeting the previous day, Miss Burnford and Mr. Astley updated the business plan, calculate the return on investment for existing shareholders in the light of the AA's reduction in conversion rates. This showed an outcome for minority shareholders, that the outcome for minority shareholders appeared somewhat less attractive. And that short section in 2.11, going through to 2.11.4, where you'll find at the conclusion, last 3 lines of that paragraph, Mr. Slingsby's figures produced a better outcome for all the shareholders at the end of the earn-out period, by implication reaffirmed the represented customer numbers previously provided by AA. So, I mean, that is one specific example where clearly the representations were, the discussions were with, and the representations were being made to my clients as shareholders, quite separately from the company's position. We then, as your lordship rightly said, from 2.14, we describe in more detail the various representations, including the key email at 2.16, which you may have noticed when first reading this makes an express written representation of immediate access to AA member base, 4 million personal, 9 million B2B members. So on the basis of what was said in the discussions and the correspondence, we set out, as your lordship's identified in paragraph 3, representations which we've defined as the immediate access representation, the implied honesty representation, and we then deal with the fact that those representations were repeated and that the claimants relied upon them in choosing AA instead of Solera and concluding the agreement, the investment agreement. There's then a separate section in 4 about the business plan, which the court will have seen, where again we say false representations were made by the AA in that document as it was prepared between the parties, and that led to what we call the business plan representation. There was then a heads of terms, which I think the court's not concerned with, which you describe in paragraph 5. There are some further events in 6 prior to the agreements. And then in 7, we deal with the investment agreement itself.
Yes.
If the court could leave the pleading for a moment, I think it's more helpful to actually look at the contract rather than the pleading of the contract. And that should be in the supplemental bundle.
Yep. Tab 3.
Tab 3, yes. So we see it's an agreement between the managers, who are the first 2 appellants, the shareholders, all the appellants, Motoriety and the AA. And just looking quickly at the definitions, one can see that in Schedule 1, the managers and the shareholders are defined. And we can pick that up at pages 45 and 46.
So not that it matters, but there are some shareholders who aren't claimants.
There are, yes. So as you'll see, 45 is the managers, Messrs Burnford and Asplin, and 46 the shareholders. And as your lordship has just said, they include my 3 other clients, Mr Fitzpatrick, Mr Gaskell, Mr Simons, and others. So, my lord, going back to the agreement itself, the main body of the agreement, the essential terms were an initial investment by AA of 400,000, as we'll see, and the possibility of marketing, first and second marketing facilities of 400,000, which are defined on pages 18 and 19. And within the definition section, you'll see on page 20, towards the end of clause 1.1, that the vendors means the managers and the shareholders, which we've just seen. The main body of the contract is at clause 2 on page 22, which is an agreement to subscribe for 25,511 shares. The subscription price is the amount of 400,000 split into 2 tranches. And the share capital of the company is set out in Part 3 of Schedule 2. And your lordship, my lady, will find Schedule 2 at page 47, where Part 1 describes the directors, then Part 2 on page 48 describes the existing shareholders, including my clients, a total of 25,511, and that's the before position, as it were, in terms of this contract. And then the after position is set out at 49, where the AA has acquired, under this agreement, 50% of the shares in the company.
Yeah.
And, my lord, in terms of the obligations in the agreement, you'll see, just looking quickly over clause 5 on page 23, each of the managers warrants, 6 each manager in the company, 6.5 there's conflicts of interest relating to the managers, 7 further restrictions and undertakings from both the manager and the company, 8 is restrictive covenants given by the managers, and then if you could go over to page 33, see clause 12, which is the call option, which is in consideration of the payment by the AA to the vendors, who are essentially the shareholders and managers, in other words, for these purposes, the appellants. The vendors grant the investor an option to purchase the option securities. And essentially, this is an option to buy the other 50% of the shares, 25,511. We can see it proceeds with the grant of the option, the exercise of the option, consideration in 12.3, option completion in 12.4, the effective reorganisation is dealt with in 5, and there are warranties and undertakings by the vendors in 12.6, and 12.7 is conduct during the earn-out period. And it's supported by Schedule 5 to the contract, which, my lord, is at pages 52 and following. You'll see that Schedule 5, Part 1 at 52 and 53 deals with preparation of option exercise accounts and earn-out accounts. 54, Part 2 is, we've just seen referred to in the main agreement, conduct during the earn-out period. So,
just pausing there briefly, it's called an earn-out period, an earn-out consideration. Am I right in thinking that the shareholders didn't have to do anything to earn the earn-out consideration?
no, in the sense that it's operated by, I mean, the conditions are for operation are referred to in the option itself, and it's triggered by
The exercise by
EBITDA reaching 1.3 million, whatever the figure is.
But although we find in Schedule 5 obligations on AAD or whatever we're going to call it, we don't see anything there obliging the shareholders to undertake work for the company or anything else to earn the earn-out consideration.
Not there, my lord, no.
Do we find it somewhere else?
My lord, no, I don't think we do. No. I'll be corrected if I'm wrong, but no, I don't think we do.
No, it's contemplated that Miss Burnford and Mr. Astley will remain as directors.
Yes, it is, yes.
And that's in part 2.
Yeah.
Yeah.
And then finally, there's we see in clause 13 on page 36 the detailed provisions in relation to the determination of EBITDA. So the call option provisions, both the clause 12 and the schedule, are in essence an agreement within the investment agreement, which is between and only between the vendors and the AA. The company has no involvement in clause 12 at all, and on the basis that the trigger occurs and the option is exercised, my clients have a contractual entitlement following the procedures we just looked at to have their shares purchased at the appropriate value. Then finally on the contract, I think, or the clause 60, you'll see that express provision is made for terminating an existing shareholders agreement, which obviously didn't include AA, but did include the others. We don't have that in the bundle, but it's replaced by this document, and of course, as one would expect, the provisions in the company's articles governing the shareholders' relationships with each other.
Yeah.
So we say, my lord, that the investment agreement is essentially a shareholders' agreement between my clients and the AA, to which, for understandable reasons, the company has been made a party, and that it includes really as its main economic force going forward a call option which will enable the AA, if things go to plan, to purchase the rest of the company, and for my clients to be to receive consideration. And it's as the court knows, it's that contractual entitlement under clause 12 which we have lost and which forms one part of our claim.
Well, you couldn't have compelled the AA to exercise the option under any circumstance.
No, we couldn't. No.
An option is an option.
No. And our case at trial will be that, as a matter of causation, had it not been for the breaches, the AA would have done would have exercised it, and that's for us obviously to establish. But as you've seen from the facts, it's clear that the AA wanted the business because they took it and they've got it, albeit not by paying my clients under that clause. But my lord, I accept that that's not for today.
Yeah.
So, my lord, that's the agreement, and if your lordship, the court could then go back to the pleading. Where I think I'd reached page 126, where we plead out the agreement we just looked at. There is one further representation, which is the services representation. There was an agreement between the company and the AA, the license agreement, which had various services that the AA was supposed to be providing to the company in its schedule. And part of our case is that it was expressly represented to us as shareholders. The AA would provide those services. So that in 7.5 on page 128 is pleaded as a separate representation. And then in terms of the...
Sorry to interrupt, but those were services which were going to be delivered to the company?
Yes, they were. Yeah. And then we plead the obligations of good faith in paragraph 9 of the pleading, and the court will have seen that we say that it's a long-term relational contract and that the developing principles of law in this area involving fidelity and reposing trust and confidence and the other elements that the courts have identified existed in this case as between us and the AA, sufficient for the AA to be under obligations, implied obligations of good faith. We don't make a plea as to what the position was between the company and the AA in relation to the implied terms. It's not part of our case to do so. And, my lord, I do make the point that at trial, the issue for the judge will be in relation to deceit, whether the representations were made to us. The judge will not be concerned whether they were also made to the company. And in terms of the implied obligations of good faith in the investment agreement, whether those obligations existed on the part of the AA to us.
So just pausing there, if we look at paragraph 9 of the pleading,
Yes.
you say the investment agreement and so on were part of a relational transaction, and then in 9.2 there were implied terms, and you set them out. You say a distinction is to be drawn between an implied obligation to your clients and an implied obligation to the company.
Well, all our case is concerned with, my lord, is the former, not the latter. I mean, it is possible, as the court knows, most of these cases about so-called reflective loss or the principle in prudential have gone forward in circumstances where the company hasn't done anything. And there's obviously an issue which is raised in Marex as to and indeed counsel in Marix actually asked the court to consider what would happen if the company was still here and you had two claims in effect, and hence the minority dealt in detail with the question of conflicting claims. But in this case, although on the facts it's clear that the company never will be making a claim given the circumstances, if it did, and it's one of the matters that this court might want to consider in analysing this case, if it did and there were two claims, it is perfectly possible that the judge could find that there wasn't an implied obligation of good faith to the company, but there was to the shareholders, because it was in relation to them a sufficiently relational contract, etc. And that the representations were made to the shareholders, but not to the company.
Your case is that they were made to both. That's what you pleaded.
Yes, it is.
Paragraph 3.1, you pleaded reliance in 3.4, both to the shareholders and the company. And it sounds a bit unrealistic, if I may say so, for you to say, on the one hand, Miss Burnford and Mr. Astley were negotiating both on their own behalf and on behalf of the company. So they were agents of the company, and yet representations made to them were not made to the company. That sounds a bit odd to me.
Well, my Lord, I only say that in terms of the factual analysis in this case of trial, it is a possibility that the judge could see a distinction between the two, both in relation to the contract terms and in relation to the representations.
How? I see the point about the good faith obligation, but how, when the human actors are acting on their own behalf and on behalf of the company, can you say that a representation made to them is not also made to the company?
Well, my Lord, we didn't read every part of the pleading, but you will have picked up that the other shareholders were involved in the discussion, and indeed on at least one occasion, I think with Mr. Gaskell, because he was particularly concerned about what he was being told and preferred Solaro to the AA. He was telephoned by the AA personally, and as it were, brought back into line. So there's no doubt on the facts that the negotiations were being conducted separately with the shareholders, albeit, as your Lordship rightly says, the principal actors on our part, because they were directors of the company, were acting for both.
Yeah.
Can I just come back to paragraph 9 for a moment? In the investment agreement, you find an agreement by the company to issue 50% of the share capital to AA. You also find AA undertaking, presumably to the company, to provide, subject to a condition, another £400,000 by way of marketing facility. And then you find a whole lot of obligations on your clients. I think they're all obligations on your clients after that. So supposing that there is a sufficient relational aspect to import obligations of good faith, how could they not be owed to the company? It's that what we really find in the investment agreement is obligations on your clients. And then, so to speak, a deal between the company and the AA, under which the company agrees to issue shares and take the marketing facility.
Yes, I mean, in a sense, my Lord, that although this is, in this case, is called an investment agreement, it's not dissimilar to many shareholders' agreements, which are in substance agreements between shareholders here existing and a new investor. But one finds that the company, for various practical purposes, has to be named and is named as a party. And we submit that properly analysed, that is the position in relation to this agreement. As I showed the court in going through it, that the company does have some obligations. Most of them are obligations that are also placed on the managers, and the substance of the obligations is that it's the managers, my first two clients, who are undertaking those obligations. Your lordship says that's the main substance of it. So the judge might take the view at trial that given the nature of the company's, as it were, participation in the contract, it's not fairly regarded, so far as the company is concerned, as a relational contract, whereas a shareholders' agreement of this sort, as between the shareholders, it should probably be so regarded. But well, I'm not, as it were, arguing a case for that. I'm simply pointing out to the court that the matter is not necessarily straightforward, and at trial there may be some very interesting factual considerations around the representations and the investment agreement, where the judge will have to consider very carefully the role played by the various claimants in the negotiations and what was said to not only to the first two appellants who were, as it were, there in a dual capacity, but also to the other shareholders who were directly involved, participated in the negotiations, but clearly weren't acting for the company. There are, what we say, Lord, interesting and potentially very important factual issues, so that if at trial, and one mustn't forget the big picture point, that if the Court of Appeal allows this case to go to trial, the AA haven't lost anything in terms of Marex and all around it. They can argue the position at trial on the actual facts as found by the judge. And one can see that rather than having to deal with it on assumed facts, there are many factual aspects that a judge approaching this case at trial would want to consider in relation to this very point about the principle, the prudential principle, as well as obviously in relation to the underlying claim. My Lord, we then deal with the true position, in which you'll have seen in paragraph 10, and then we characterise and set out the deceit case in paragraph 11, including the knowledge of the individuals involved. You may have noticed in passing that pleaded in 11.3 what might be described in a different context as a similar fact allegation that the same thing appears to us to have happened in relation to another company called Event Tyres. And then in paragraph 13, we set out relevant events that took place after the agreement. And there's a lot of detailed fact, as you'll have seen, which we're not presently concerned with, following through the demise of the business and ultimately its acquisition by the AA. And as we say in our skeleton argument, as we understand it, having put the business into administration on one day and bought it back for £20,000 on the next, the business has continued to be successful, and its profitability has gone up from 300,000 to 1.3 million or something of that sort, and we don't know beyond that because obviously it's the AA's business. But our understanding is that the wrongdoing which we allege has hugely benefited the AA while completely denuding my clients of the interest that they have in the business. So, my Lord, we then set out at 14 the breaches of agreement, and finally at 15 the falsity of the so-called services representation. And then in paragraph 16 go on to loss, damage and remedy. And it was this part of the pleading which the court will have seen we made some short amendments to. So first, the misrepresentation deceit claim is that the shareholders would not have entered into the investment agreement but would have concluded the envisaged venture with Solara on the terms of their proposal, or substantially similar terms, and as a result of entering the investment agreement, they've suffered loss and damage, and that loss and damage is a diminution in the value of their shares, as summarised at page 153, Schedule 1A, the top part of that table. So the deceit, from my client's point of view, caused them to enter the agreement with this party rather than the other. Their case is that had they entered it with Solara, the position would have been very different, and the task at trial would be to calculate the value of their shares on the basis of that hypothetical. Anticipating the submissions in relation to the prudential principle, my Lord, it is not our case that the company suffered loss through deceit and that had a knock-on effect on the value of our shares. That's not our case. Our case is a self-standing, separate and independent claim in deceit on the basis of representations which were made to us and which we relied upon, and which we would not have relied upon had we been told the truth, but would have acted differently. And although the calculation of the loss is by reference to the diminution in the value of our shares in the business, in the company rather, we say that has nothing to do with and is not within the principles we're going to look at, merely because the company suffered loss and as a knock-on consequence of it doing so. So, well, that's the first part of 16. 1616A adds, on page 148, adds a further and much smaller claim, as the court will have seen, by the three, my third, fourth and fifth clients, Mr. Fitzpatrick, Mr. Symes and Mr. Gaskell, that as a result of the events which actually occurred, they were unable to recover their initial investments in the company.
And just to be clear, the initial investments are the sums they paid for their shares?
Yes. And we then move on, my Lord, at the beginning of the bottom of 148 to breach of contract claim. We plead in 1621 the claimants are entitled to damages on the basis that the venture would proceed in accordance with the intended and agreed terms of the investment agreement. And over the page, we plead in 1625 the value of the claimant's shareholdings in Motoriety will be subject to expert evidence, etc., but without prejudice to this. And then you will see that the calculations at 154 in Schedule 1B for breach of contract diminution in share value, which are where the sums are much larger than they are in Schedule 1A. It's the top part of page 154. And then in 16.2a...
just going back to 16.2.1 for a moment. You say that the claimants are entitled to damages on the basis that the venture would have proceeded in accordance with the agreed terms and so forth. You then go to value of claimant shareholdings. There isn't necessarily a pleaded link between the two, but I take it to be implicit that you are saying that if the venture had proceeded in accordance with these various documents, the claimant's shareholdings would have been that much higher.
Yes. Yes, my Lord. And then, my Lord, just going back to the bottom of page 149, 16 26A. Alternatively, had it not been for the AA's breach of contract, it would have exercised the call option under Clause 12 and paid the initial option payment earn-out consideration as defined. Due to the breach of contract, the claimants have suffered loss. And that is the amount of 154, I'm sorry, the bottom of Schedule 1B. So
Yeah.
1B Table 2, which is a sum as presently calculated of a little over 31 million. And, my Lord, when we come to the application of the principles that my learned friend relies upon, what is clear is that what we have lost under Clause 12 on this alternative basis as damages, as the loss for breach of contract, is a contractual entitlement. That's the claim. And the authorities are clear that the way in which you calculate the loss, the amount of the loss, is not relevant for the analysis in relation to the rule in Prudential. This is not a case where the company had any claim at all. It didn't have any contractual entitlement of this sort. Only we did. And our claim is that we have lost that entitlement, and that therefore, if we're right, the judge at trial will have to decide how that would have worked through and how one then operates Clause 12 in order to determine the amount of the loss, which we've summarised at page 154 somewhat briefly. There's a helpful table I won't take you to, it's attached to our witness statement, which shows the breakdown and how the formula is worked out in more detail to reach that, the sum of 31 million odd. So
just unpacking that a little. You say you had a contractual entitlement. You had a contractual entitlement if the AA chose to exercise the option.
yes,
And the AA might choose to exercise the option if that meant that they could acquire valuable shares at a reasonable price.
yes,
So your case depends on the shares being of such a value that the AA would think it worth its while to exercise the option.
yes. Well, and on the facts we're assuming, that would have been the case.
Yes.
But the operation of the provisions we looked at in 12 and Schedule 5 to the investment agreement are really a relatively standard way of calculating what the draftsman's referred to as an earn-out, and calculating the initial option payment, the earn-out consideration, etc., under the contract. But the contractual entitlement itself, once the option's been exercised, is the claimants and not the companies. And so, in our submission, that alternative claim in breach of contract on any view falls outside the prudential principle altogether. And it's certainly not an answer to that, to say, in effect, oh, but if you look at those provisions, they look a bit like calculating the value of the shares. I mean, self-evidently, contractually, that is exactly what they are. But what we have lost is a contractual entitlement, and it's a matter for the judge at trial to say, if we're right, how those provisions would have operated to quantify the amount of that loss. So, my Lord, that's our pleaded case and the investment agreement. So far as the facts are concerned, the court will also have seen the summary of the positions in relation to the company itself. The investment agreement was dated the 28th of August. It might be helpful to just take the court to the chronology, which is, I think, in the core bundle. Tab 3, thank you, Melanie. blissfully brief chronology. So we see that initially Motoriety is formed in 2013. The discussions, as we've seen from the pleading, took place in 2015.
Yeah, it went into administration in 2017. The AA group bought the assets, and then Motoriety got dissolved.
Can I raise a trivial point on that? It says in the chronology that joint administrators were appointed on the 24th of April. I see in the defence it says that Motoriety went into administration on the 5th of May. Now, nothing can turn on it, but can we say which is right?
I can't. I can't say which is right. No. But in any event, your lordships,
yeah. Anyway, it looks like a pre-pack.
Yes. And it goes into administration. The assets are purchased, and then it's dissolved in June 2019. There's then, although it's not in the bundle before the court, there were detailed pre-action protocol letters passing between the solicitors during 2020 and early 2021. And you will have seen from paragraph 5 of our skeleton, I won't take you to it, we point out that no mention was ever made of so-called reflective loss until the defence served after 3 months of extensions of time on the 27th of August 2021, almost exactly 6 years after the date of the investment agreement. And the court will have noted, hopefully forgiving us for being cynical, that it would rather appear that the matter was left until such time as it could be said as certainly as possible that the company was never going to be able to make a claim, because then the claim would be told.
Again, nothing can turn on this, but according to the chronology, the particulars of claim were served on the 3rd of June, and the defence was served on the 27th of August. That's not an enormously long time. Most of the 6 years has expired before you served your particulars of claim. I mean, I suppose you would have potential cause for concern, at least, if you could have done something, if the defence had been served, say, a month earlier, such as causing the company to bring proceedings. But that's not suggested, is it?
Well, it's I suppose, unfortunate from my point of view that I don't have a series of long letters to wave at the court. But I mean, if you go through, we'll look at the initial Stewart's claim letter in the context of the settlement agreement in 2020. I mean, there was detailed correspondence, and one can only, in fairness to my clients, conclude that this point was deliberately not mentioned until the time it expired.
Well, let's assume that to be the case. How does it bear on this appeal? I mean, I can see that if you were saying some sort of an estoppel had arisen, it might be relevant, but you're not saying that.
No, I'm not. No, I think your lordship might describe it as a jury point.
Yeah, well, there are only 3 of us here, Mr. Earl, not 12.
So, Lord, that is the claim and the background to the claim. And to the extent the court needs to look at them, the relevant facts from the pleading. This case is, on any view in our submission, somewhat unusual, because in terms of approaching reflective loss, one is concerned with a situation where the claimants are 50% shareholders in a company, and where the defendant is the other 50% shareholder, which is not a situation that, as far as we're aware, has come up in other cases. So there's what the defendant conveniently says should have happened is that the company should have commenced fraud proceedings claims and bad faith breach of contract proceedings against its own 50% shareholder in circumstances where the company directors not only included representatives of the AA, but I think I'm right in saying included the individual who was actually at the centre of the deceit. So it's an unusual proposition to be saying to the court that that is a fair way of dealing with my client's claims, that essentially they should be struck out to enable, even if the company was now able to do it, to enable a company to sue in fraud against its 50% shareholder and its own directors. And certainly if one were dealing with the ordinary administration of the case and not the highly specific exception in prudential, there is no way that the court would consider not enabling this case to go to trial. And if it happened that the company in different circumstances were making some claim, for example, for loss of profits as a result of some of the same or similar wrongdoing, then so be it. There would be two claims which could easily be, in our submission, case managed.
But that's the minority view in Marix.
Yes, well, and
there's no doubt a lot to be said for it. But nonetheless, it was the minority view. The majority view is there is a substantive rule of company law under which what we can call for shorthand a reflected loss is not a loss that the law will recognise. That's what the majority say.
No, my lord, I'll come on.
Fair or not? I mean, that they say that's the law.
Yeah, I'll come on very shortly to the key authorities and to look at exactly what that means. But in terms of these claims, in our submission, it's quite clear that the claim, the clause 12 claim, if I can call it that version of the contract loss, and the initial investment claim, have nothing to do with the company and could self-evidently have proceeded, even if the company was itself making a claim for loss of profits for deceit. And while the court would, in those circumstances, have to case manage those claims at trial, my lord, as I would see it, the judge having found the facts, and that let's assume on this analysis awarded the company 30 million against the AA, the judge would then have to decide how clause 12 under the contract operated and how it could be operated in favour of the shareholders.
But this isn't really about case management. If you're right, and the clause 12 claim and the initial investment claims are not barred by the rule, that's what you say, then they can go forward. If, on the other hand, they are barred by the rule, they can't.
Yes, my lord, I
No matter what case management expedients you devise.
So, my lord, moving on to the law, I appreciate that the court has very helpfully read the principal cases. I was going to go quickly to 4 of them, starting with prudential and going through to prudential. And those are, the court will find prudential first in the authorities bundle tab, volume 1, at tab 2. I thought I know the facts are well known to all company law students because it's such a well-known case. The claimant was prudential. The first defendant is the company, Newey Industries, and the second and third defendants were Mr. Bartlett and Mr. Lawton, who were the directors of Newman. And essentially, my Lord, Newman agreed to buy certain assets from another company called TPG at an overvalue. Bartlett signed an agreement for the purchase. Under the stock exchange regulations, the agreement needs to be approved by the shareholders of Newman. An extraordinary general meeting of Newman was convened, and a circular was provided to the shareholders Prudential was claiming on behalf of themselves a personal claim as well as on behalf of Newman a derivative claim, and the claim sought damages against Bartlett and Lawton for conspiracy and breach of duty. And the matter came first before Mr. Justice Vinelott, and in the judgment, our Lord, having gone over the head note, I'll use the case page numbers if I may, 208F. The findings, before we get to the Court of Appeal judgment, the findings of Vinelott J are recorded. Vinelott J found that Mr. Bartlett and Mr. Lawton had conspired to injure Newman and indirectly the shareholders, with the result that Newman had acquired TPG's assets for $445,000 more than Newman need have paid for them. He held that since the plaintiff's personal, derivative and representative claims are all founded on the conspiracy to injure Newman, there was no objection to them being joined in one action. And in the Court of Appeal, the judgment, Lord Justices Cumming, Bruce, Templeman and Brightman starts at the bottom of page 26.
Yeah. One of the remarkable features of this case is how long the Court of Appeal gave it. Look at page 204, and I haven't counted up the number of days, but I don't think you get that many days out of this court now.
Yes, I haven't seen that. Gracious me, yes. So the court dealt first with the derivative claim, and then if we go to page 222, at just above D, the Court of Appeal turned to the personal claim.
So 222.
222, yes, my lady, I'm sorry. Just above D on the right-hand side. In the amended prayer, the plaintiffs in their personal capacities as shareholder claimed damages for conspiracy against Bartlett and a declaration. Then the next paragraph, Vinelott J upheld the plaintiff's personal claim and also the representative claim with which it was linked. He began with the proposition, which accorded with his findings, that Newman had been induced by fraud to approve an agreement under which Newman paid more than the value of the assets acquired, and thus $445,000 more than it needed to pay. Therefore, Newman's indebtedness to his bankers immediately after the transaction, about $5 million, was more than it would have been but for the fraud. Therefore, the fraud caused a reduction in net profits, which must have affected the quoted price of Newman shares. Therefore, the plaintiff suffered some damage in consequence of the conspiracy that was sufficient to complete the cause of action. The Court of Appeal then turned to deal with it themselves. They say the claim is misconceived in just above G, and then fourth line down in that paragraph, it's also correct that if directors convene a meeting on the basis of fraudulent circular, a shareholder will have a right of action to recover loss which he has been personally caused in consequence of the fraudulent circular. This might include the expense of attending the meeting, but what he cannot do is to recover damages merely because the company in which he is interested has suffered damage. He cannot recover a sum equal to the diminution in market value of his shares or equal to the likely diminution in dividend, because such a, quote, loss is merely a reflection of the loss suffered by the company. The shareholder does not suffer any personal loss. His only loss is through the company, is the way they put it. And then just below B, the deceit practiced upon the plaintiff does not affect the shares. It merely enables the defendant to rob the company. And the Court of Appeal then give the famous cash box example, which has been much discussed in textbooks and academia since.
Marix as well.
Yes.
It's discussed in Marix.
Yes, it is as well, yes.
So this is a case in which the question was, should the shareholders support a resolution enabling the company to buy some assets?
Yes.
And Mr. Bartlett and Mr. Lawton owed a duty to the shareholders to give advice in good faith.
Yes.
That was a duty owed to them as shareholders and apparently not to the company. because it's the shareholders who are going to decide whether or not to pass this resolution. Is that right so far?
Yes.
So this is a case in which the shareholders have a remedy against, the shareholders have a cause of action against Mr. Bartlett and Mr. Lawton, but the company does not.
That was their contention. Yes.
So that seems to be what the Court of Appeal decided.
And
But that cause of action could result in damages, such as the expense of attending the meeting, but could not result in damages representing any diminution in the share value.
no,
That seems to be what they decided. Is that right?
because, and this is where the infamous term reflective and
Yes.
reflection comes, because the damages to the company and the claim by the shareholder is that as a result of the damage to the company, there's a knock-on effect, as it's put in Mareks. The share price has been affected or reduced. That's the starting point in prudential. And we submit it's an extremely limited exception, as indeed we'll see it was described by Lord Reed in Mareks. But there's no doubt at all that prudential was not concerned with a case where the shareholder had an independent claim for loss which was not reflective or dependent upon the damage caused to the company. So that's prudential. In the same bundle at tab 9, you will find
My tab 9, I think, is in the next volume. Wood and Capita.
oh, it's tab 7, I'm sorry, tab 7.
So we're going to Johnson and Gore Wood.
Yes. Now, in Johnson, which of course, as the court has seen, has been dealt heavy blows in Mareks.
Yeah.
The only section which I wanted to show you is at bundle page 223, which is in the judgment of Lord Bingham, which, as
Yes.
we'll see, is effectively upheld and approved in Mareks, unlike the judgment of Lord Justice Lord Millet. I'm sorry. So this case, again, as you may remember, Mr. Johnson, the claimant, conducted business through a number of companies. He instructed Gore Wood in connection with the purchase of land. The transaction involved the exercise of an option granted by Mr. Moores, and the company instructed Grove Wood to serve a notice exercising the option. They served the notice, but Mr. Moores contended it had not been validly served. So the company, WWH, then issued proceedings against Gore Wood for negligence. There was delay in executing the option. It was more than 4 years after the exercise of the option the land was finally conveyed. The company brought proceedings against Gore Wood. The claim came to trial, but midway through was settled by Gore Wood. And then, having compromised, Mr. Johnson brought a personal claim against Gore Wood. That's how the issue arose. And the basis for his claim was that Gore Wood, he said, had acted for him personally on a number of occasions. So that, like Prudential, this was a case where the loss was reflective in the sense that it's properly used. It was merely a knock-on consequence of the damage to the company. And if we go to bundle page 223, we see that Lord Bingham at D refers to the various authorities. This is under the heading on the previous page, the recoverability of damages claimed by Mr. Johnson. He refers to a number of authorities, including Prudential. And then just below E, these authorities support the following propositions, and he then enumerates 3 propositions. The first, where a company suffers loss caused by a breach of duty owed to it, only the company may sue in respect of that loss. No action lies at the suit of the shareholder suing in that capacity, and no other to make good a diminution in the value of the shareholder's shareholding, where that merely reflects the loss suffered by the company. A claim will not lie by a shareholder make good a loss which would be made good if the company's assets were replenished through action against the party responsible for loss. So, my lord, that is the classic prudential position that the court knows that it's the rule in Foss and Harbottle.
Well, it's a bit more than that, isn't it? Because as I think you accepted when I asked you, the shareholders in Prudential had their own cause of action for fraudulent advice. So Lord Bingham's statement, which he says is clear from Prudential, is that a claim will not lie by a shareholder pursuing his own cause of action to make good a loss which would be made good if, and so forth. That must be what he means, because that was Prudential. The shareholders had their own cause of action. So it's not just Foss and Harbottle, which applies to the company's cause of action. That's clear. It's the shareholders' cause of action.
But the underlying, I mean, there have been many, as your lordship knows, many justifications put forward for the rule over the years, and some of them are in the recent cases as well. But the underlying reason has always been said to be that the company and its management should retain control of the company's claims and cause of action, and not and save in the exceptional circumstance of a derivative claim where the shareholder has taken over the action on behalf of the company. When you become a shareholder, you sign up to being a shareholder, and you entrust the management with pursuing the company's claims. What you don't do is entrust anyone else with pursuing your separate claims. Anyway, my lord, that was proposition 1.
Yeah.
Proposition 2, where a company suffers loss but has no cause of action to sue to recover that loss, the shareholder in the company may sue in respect of it if he has a cause of action to do so, even though the loss is a diminution in value of his shareholding. There's a reference to Lee and Sheard and George Fisher. 3, where a company suffers loss caused by a breach of duty to it, and a shareholder suffers a separate and distinct from that suffered by the company, caused by a breach of duty independently owed to the shareholder. Each may sue to recover the loss caused to it by breach of duty owed to it, but neither may recover loss to the other by breach of the duty owed to that other. And although that's a little complex in one sense, but again, Lord Bingham is reflecting the principle in Prudential that where there is a separate claim by the shareholder, which is not reflected, where the loss is not reflected, in other words, where it's not simply because the company has been damaged, I say my shares are worth less, then as a matter of principle, the shareholder should be able to proceed with their separate claim. And then on the next page, my lord, at B, Lord Bingham says these principles do not resolve the crucial decision which a court must make on a strikeout application, whether on the facts pleaded a shareholder's claim is sustainable in principle, nor the decision which the trial court must make, whether on the facts proved the shareholder's claim should be upheld. On the one hand, the court must respect the principle of company autonomy, ensure that the company's creditors are not prejudiced by the action of individual shareholders, and ensure that a party does not recover compensation for a loss which another party has suffered. On the other, the court must be astute to ensure that the party who has in fact suffered loss is not arbitrarily denied fair compensation. And he says, as we see, the problem can be resolved by close scrutiny of the pleadings at the strikeout phase. and all the proven facts at the trial stage, the object is to ascertain whether the loss claimed appears to be or is one which would be made good if the company had enforced the full rights against the party responsible. He refers to the phrase merely a reflection of the loss suffered by the company, and then goes on, in some cases the answer will be clear as whether shareholder claims the loss of dividend or diminution in value of the shareholding attributable solely to the depletion of the company's assets, or loss unrelated to the business of the company. In other cases, inevitably a finer judgment will be called for. At the strikeout stage, any reasonable doubt must be resolved in favour of the claimant. And the court knows from our skeleton that we do pray that important passage in aid in this case. Whether or not one describes this rule as a bright line or a clear line or whatever, for following Mareks, which we're about to come on to, it's clearly important where there are issues of fact around the application of the principle that the claimant should be given the opportunity to take the case to trial and have the judge decide the detailed facts so that all the various complicated aspects of applying the rule in a circumstance such as this, where our case, where the shareholders clearly have a separate claim in deceit because the representations were made separately to them, they clearly have a separate claim in breach of contract to which they are separately a party. I would respectfully adopt the terminology which Lord Brigham used of a finer judgment.
Well, wait a minute. Lord Bingham certainly indicates that one can scrutinise such a claim at the stage of a strikeout.
Yes.
And the question then is not what's the cause of action. The question is whether the loss claimed appears to be, that is because it's a strikeout, one which would be made good if the company had enforced its full rights against the party responsible. And if the answer to that question is yes, it would, then you're within the rule and the claim can't go forward.
Yes.
So you say that it's important that where there are factual issues, but at the strikeout stage, we assume you win on all the factual issues. We take the pleading at face value and we ask ourselves, let us assume you prove what you set out to prove. Is the loss you claim one which would be made good if the company had enforced its full rights against AA developments?
Yes. Well, that in itself, my Lord, I simply make the point, that in itself is a fact-sensitive issue. It may be very difficult to determine on the facts of any particular case. And one sees in both in these cases and in Mareks itself, recognition of the fact, for example, that the box example may not be as helpful as it originally appears, because the value of the shares don't necessarily reflect and often don't reflect the assets of the company. So it's not simply a question of saying you've stolen the box and my shares have gone down by the same value. There may be a very difficult, and we can see in this case, there would be a difficult exercise for the judge in calculating what loss the company has suffered by way of loss of profits, if that was the claim that which one presumes it is, it would be making in both deceit and breach of contract, and whether, if it had recovered those profits, the shareholder's separate claim would have been satisfied, as it were. But my Lord, we do say that in both these cases, Prudential and Gore, in both cases, the same principle is being applied, namely that the damage to the shareholder is a knock-on effect of the damage to the company, not something different. And on any view in our submission, as my Lord has already identified, the Clause 12 case and the initial investment case are outside that principle.
Can I just test that for a moment in relation to the initial investment case? your clients had exchanged £250,000 for shares in the company. They no longer had £250,000, they had shares in the company. So now we ask whether the loss we're talking about is one which would be made good if the company had enforced its full rights. Well, why wouldn't it? I mean, it's just, if you've lost your £250,000, that's because the shares have become valueless. You didn't have a separate £250,000.
No.
So why wouldn't the loss you're talking about be one that would be made good if the company had enforced its full rights?
Well, and all that depends, obviously, on what enforcement by the company of its full rights involved.
Well, the company pursuing a claim in deceit, for one thing, because you say that these representations were made to the company.
Yes. Or
And in relation to the services.
I mean, on your case, the company would have done a deal with Solera, not the AA. And had that happened, all would have turned out very well. And you wouldn't have lost your £250,000 because the shares would have been worth much more than £250,000.
Yes. So, my lord, in terms of the authorities, I was going to turn next to Marex, which I know that the court's already looked at, and just go to the, if I may, to the key passages. That is at tab 13. I think it's in bundle 2.
Yes.
Now, the facts of this case are involve essentially an appalling asset stripping exercise. The court will have seen Mr. Civilager, the defendant, was the owner and controller of 2 BVI companies. Marex brought proceedings against the companies in the commercial court and obtained judgment. After the draft judgment was circulated, he procured that the companies transferred the funds offshore to his personal account with the object of ensuring that Marex couldn't enforce its judgment. And as we see from the head note, Marex then brought proceedings against him for inducing or procuring the violation of its rights and for intentionally causing Marex to suffer loss. And essentially, there were, as we'll see in a moment, there were 2 issues. Does the reflected loss rule apply to creditors? And is the scope for the court of admin proceedings to go ahead, even if they do, on grounds of justice, which is the Giles and Rind exceptions that had come to be called following Johnson and Gore Wood. So, although Marex has now, as it were, become the leading authority on the rule in prudential, because it's been, as it were, put back in the correct box and properly defined by Lord Reed, by the majority. The case itself did not concern shareholders but creditors, and all the Supreme Court justices agreed that it didn't apply to creditors, which, had it not been for what had happened in Johnson and Gore Wood, one would have thought was, with due respect, a relatively straightforward proposition. And looking at the matter broadly, it does leave a position where, and the court may have seen a rather amusing extract from Master Stevens in the Breeze case, where she said that the court had chopped down the Japanese knotweed of reflective loss, but hadn't provided a full gardener's guide. And what she meant, and she's right, is that although the principle has now been properly redefined back to its prudential roots, if I can put it like that, Marex did not involve the Supreme Court really considering the circumstances of shareholders beyond a restatement of the basic principle, because it was a case that related to creditors and not shareholders. So, as your lordship has seen, it's the judgment of Lord Reid that we're principally concerned with, and then a couple of passages in Lord Hodge. Lord Reid's judgment starts at bundle page 396.
Yeah.
And we see, just looking over the first few paragraphs quickly, that he does set the context, a context which, as my lord's already pointed out, is taken up by the minority, of two different people suffering loss as a result of the wrongdoing of a third. And the broad question, at least as a starting point, as to how that should be dealt with. And he explains on the next page, 397, through paragraph 4 down to 7, the practicalities that, procedural practicalities that are involved in dealing with such claims for loss by different parties against the same defendant. And then at 8, on 398, he says this appeal is concerned with a particular type of situation in which two persons, A and B, suffer loss as a result of the conduct of a third, C. The situation in question is one in which A is a company, B is a creditor of the company. B's loss is consequential upon the loss suffered by A. The fact that a claim lies at the instance of a company rather than a natural person or some other kind of legal entity does not in itself affect the claimant's entitlement to be compensated for wrongs done to it, nor does it usually affect the rights of other persons, legal or natural, with concurrent claims. There is, however, one highly specific exception. He calls it to the general rule, and he then refers to Prudential and Newman, that a shareholder cannot bring a claim in respect of a diminution in value of his shares or reduction in distributions which he receives by virtue of his shareholding, which is merely the result of a loss suffered by the company in consequence of a wrong done to it by the defendant, even if the defendant's conduct also involved the commission of a wrong against the shareholder. The court has seen that the judge, when we put before him the phrase merely the result of and similar phrases, sought to, as I understood it, to say that these were all simply a reference back to Prudential and the wording in Prudential, and that the word merely could somehow be ignored for the purposes of the present case. That's not right, my lord, with respect. It's quite clear that throughout this judgment, Lord Reid is confirming what was found in Prudential, and the loss, the shareholder's loss, has to be merely the result of a loss suffered by the company in consequence of a wrong done to it, accompanied by the defendant. He then defines the principle as the rule in Prudential in paragraph 10, which is a description he prefers to reflected loss principle and uses throughout the judgment. The issues in the case, my lord, are at the bottom of page 400 at paragraph 22.
So just before we go there, the point that he makes at 10 is that where the rule in Prudential applies, the shareholder does not suffer a loss which is recognised in law as having an existence distinct from the company's loss. That's the key point.
Yes. My lord, in circumstances where that loss is a loss of share value caused by damage to the company.
Yeah.
That's the point.
Right, you want us to go to 22, did you say?
Yes, I'm sorry. 22 simply.
Yeah.
Those are the two issues anyway. I mean, the first one is, does it apply to credit? And the second is, for want of a better shorthand, Giles and Ryan, is there a sort of injustice exception?
Yes.
And essentially what the Supreme Court do is reduce this principle back to its roots in Prudential, in which case there's no need for the subsequent jurisprudence through Johnson and Gore-Wood, and including the jars and rhyme exception. That's perhaps an oversimplification, but that's certainly how I would respectfully read it. And that's why that exception went.
Well, once you accept that it's a rule of company law, not a question of case management, either you're within the rule or you're not.
Yes.
So, as you say, there's no scope for some sort of procedural exception you find in jars and rind.
So he deals with prudential on 401, paragraph 23. And we've already looked at the case itself, but in 26 at the bottom of that page, he refers to that paragraph at page 222 in prudential. What the shareholder cannot do is recover damages merely because the company is interested in has suffered damage. Cannot recover a sum equal to diminution in market value of his shares or equal to the likely diminution in dividend because such a loss is merely a reflection of the loss suffered by the company. As that passage makes clear, says Lord Reed, the decision was concerned only with the diminution in value of shares or distributions suffered by a shareholder merely because the company had itself suffered action or damage. It was not concerned with other losses suffered by a shareholder or with situations where the company had not suffered any actionable loss. So we submit that it's clear that Lord Reed is indeed very deliberately confining the principle back to prudential, and that to the extent that it's an important point in this appeal, it does include the use of the word merely because the company had suffered actionable damage.
Just on this merely, as you say, the judge is concerned to say it echoes prudential. What do you say it means, that the word merely?
Well, that is the only circumstance that one is concerned with. In other words, is the loss which one is concerned with in the context of a shareholder, is it said to have arisen merely because the company has suffered loss? Or is it said to have arisen, as it is in this case, because the shareholder has its own self-standing claim and was itself deceived or the subject of breaches of contract?
But that, expressed that way, if I've got it right, that doesn't quite make sense because, say, Lord Bingham's category 3 has two elements. You have to have your own cause of action and you have to have distinct loss. And I think the formulation you were putting a moment ago says, well, you have to have your own cause of action, but you have to have your own distinct loss too, don't you?
Yes.
I think Lord Reed goes on in the next paragraph, 28, to explain exactly what he does mean.
Yes, my Lord, I was just going to go to that.
Where a company suffers actionable loss, and that loss results in a fall in the value of its shares or in its distributions, the fall in share value or in distributions is not a loss which the law recognises as being separate and distinct from the loss sustained by the company. So that's what he means by all that, merely.
Yes. And, my Lord, that's right. And as Lord Reed says, that's the beginning of the passage that your Lordship has just read, where a company suffers actionable loss.
Yeah.
That's the position that this is concerned with. Now, Lord Reed then deals with the cash box example over through to paragraph 31. And then if the court go to 32, he goes on to deal whether a company suffers loss, that loss may affect its current distributions or the amount retained. At the end of that paragraph, you'll see a reference to market sentiment, which is a reference to Lord Millett in the Johnson case, Gore-Wood case. And then the last four lines, Lord Reed says, if the company's loss does not affect the value of its shares, then there is no claim, or at least no sustainable claim, available to the shareholder. And in principle, the problem addressed in prudential does not arise. The problem only arises where, as in prudential, a shareholder claims that the company's loss has had a knock-on effect on the value of his shares. And that, as we'll see, is a phrase that's taken up by the Privy Council in Promeo, and which we would respectfully recommend to the Court of Appeal in this case.
Can I just ask a supplemental on this? Is it right that prudential can apply even where the loss to the shareholder in terms of shareholder value doesn't exactly correspond to the loss to the company? If the change in the value of the share reflects loss to the company, prudential can apply even if there's no mathematical equivalence between the loss to the company and the loss in share value.
Well, that in theory, my lord, that's right, but that is, we would submit, it would be in this case, and is in many cases, a very fact-sensitive exercise. I mean, one would have to clearly understand what claim the company either was making, if it was making one, or would have made in a case like this, and how that relates to the loss suffered by, I mean, in this case, our claim is very straightforward. We had two choices, AA or Solera, as shareholders and investors. If we hadn't been misled, we'd have chosen the other option. And the calculation that the nature of the loss is the value of our shares as they would have been if that had occurred.
And you're saying, really, under Clause 12, although the company is a party to the agreement, Clause 12 is focused on your clients.
Yes. So, just picking it up briefly, my lord, at paragraph 35 on page 4.
So can I just ask you about 33, because there's a bit I don't quite understand now.
Yes.
What Lord Reid says, the beginning of 33, is considering the situation where a company suffers actionable loss as a result of wrongdoing, the company acquires a right of action, as I understand. If the company's loss results or is claimed to result in a fall in the value of its shares, then but for the rule in Prudential, the shareholder would simultaneously acquire a concurrent right of action. I don't understand that. Why? Why would the shareholder have a concurrent right of action merely because the company had been wronged? I don't understand that.
No, my lord, I don't either. I think he means that, and a separate claim.
Well, the shareholder might or might not have a separate claim.
Yes.
I think he must be assuming that the shareholder does have a separate claim.
Yes. Yes.
Yeah, 35.
And then 35, Lord Reid, having asked the question in the previous paragraph, says in Prudential the court answered that question in the negative, stating that the rule in Foss and Harbottle would be subverted if the shareholder could pursue a separate action. The rule, as restated in Edwards and Halliwell, and he refers to the first aspect, the proper plaintiff in an action with respect to a wrong alleged to be done to a corporation, is prima facie the corporation. And while there are other justifications or claim justifications for the rule, my lord, that is the underlying driver for the prudential rule, namely that it's important as a matter of company law that the company and its management have control over the company's claims, and that a shareholder, however big his interest in the company, and in the absence of taking on the company's claim himself, cannot bring the company's claim or a claim on behalf of the company. That's where this it starts, and in our submission, properly analysed, it's where it finishes. So if it's a separate claim by the shareholder, and it's not a claim that my share value's gone down because the company was damaged, it doesn't fall within the rule, we would submit. Paragraph 36, my lord, over the page. He says, accordingly, in a situation where a shareholder claims that his shares have fallen in value as a result of a loss suffered by the company, and the company has a right of action in respect of that loss, the shareholder can exercise such rights of control over its decision-making as have been granted to him by the articles. These normally provide ultimate control for the majority of the shares, and a minority shareholder has other remedies. So to the extent that I think my learned friend suggested at first instance that my client's remedy was to issue a dreaded Section 994 petition, rather than proceeding with a relatively straightforward claim as they are doing to recover the loss. That, with respect, isn't right, because what Lord Reid is pinning this again quite clearly to the position where the company has a right of action in respect of the damage to the company, not where the shareholder has a claim and has an entirely separate and self-standing claim.
But is that right? 36, Lord Reid is not focusing on the claim, focusing on the loss. The shareholder may have a self-standing separate claim, but if the claim is that the shares have fallen in value as a result of a loss suffered by the company, not a wrong done to the company, then he can't claim it.
No, my lord, it's more. I'm conscious of, as it were, repeating myself by reference to similar passages in these cases, but it's the point throughout is that the loss is to the company, and the shareholder's claim is that because the company's suffered a loss, my shares have gone down in value, and I want to claim for that, for the diminution in value. And then the Lord Reid continues this part of his judgment of 406, paragraph 39, where he finishes his consideration of Prudential. In summary, therefore, Prudential decided that a diminution in the value of a shareholder or in distributions to shareholders, which is merely the result of a loss suffered by the company in consequence of a wrong done to it by the defendant, is not, in the eyes of the law, damage which is separate and distinct from the damage suffered by the company and is therefore not recoverable. Where there's no recoverable loss, it follows the shareholder cannot bring a claim whether or not the company's cause of action is pursued. The decision has no application to losses suffered by a shareholder, which are distinct from the company's loss, or to situations where the company has no cause of action.
I suppose in theory, if your claim is a breach of contract, you might get £2 nominal damages. But
I suppose, yes. Yes, one would hope not, my lord, but yes. His lordship then deals with Johnson and Gall Wood, which I've already taken the court to helpful passages from Lord Bingham. He starts at paragraph 41 by quoting the passage we looked at. And then if we could go to 42, Lord Reid says, in Lord Bingham's proposition 1, the first sentence is a statement of the rule in Foss and Harbottle. The second sentence encapsulates the reasoning in Prudential and explains why, in the circumstances described, a shareholder who is suing in that capacity and no other cannot bring a claim concurrently with the rule in Foss and Harbottle. He says the third sentence should not be understood as limiting the rule in Prudential to cases where there's an exact correlation between the company's loss and the fall in share value. He then deals with proposition 2 and with Lee and Sheard at the bottom of that page. And then over the page, having also dealt with the George Fisher and Gerber Garment technology cases in 45 and 46, in paragraph 47, he goes on to Lord Bingham's proposition 3, as he says, stating put shortly, a shareholder can sue to recover a loss which is separate and distinct from that suffered by the company, reflects the fact that the shareholder's loss, where it does not consist merely of a form of value in his sharing or distributions, which he receives by virtue of his shareholding, does not fall within the ambit of the rule in Prudential. He then quotes with approval in paragraph 48 and how the court should apply the relevant principles, including the passage I read to the court from Lord Bingham in the first passage quoted in Lord Reed's paragraph 48. On the other, the court must be astute to ensure the party has in fact suffered the loss, is not arbitrarily denied fair compensation.
And does Lord Reed accept then that the rule does not bar a cause of action, it merely limits the recoverable loss?
Yes.
So in this case, you say there are two claims. There's a claim in deceit and there's a claim in contract. Claim in deceit is not a complete cause of action unless there is recoverable loss.
Yes.
The cause of action in contract is complete when there's a breach, whether or not you suffer loss, subject to nominal damages. So if we're looking at this case at the strikeout stage, if it is the case that none of the losses you claim are recoverable in tort, your claim goes. The contract claim, on the other hand, survives as a cause of action, but if the losses that you claim could only ever be £2 nominal damages, the claim would be liable to be struck out, would it not, on a sort of Jameel and Dow basis, as being not worth, the game's not worth the candle, as it was put in one of those cases. Is that right?
Yes. And Lord Reed concludes his analysis of Johnson in paragraph 67 on page 414. We see, in summary, Johnson gives authoritative support to the decision in Prudential that a shareholder is normally unable to sue for the recovery of a diminution in value of his shareholding or in distributions he received as a shareholder, which flows from loss suffered by the company, for the recovery of which it has a cause of action, even if it has declined or failed to make good that loss.
I'm sorry, I wasn't keeping up, Mr. Oliver. Which paragraph?
Oh, sorry, it's 67.
67.
At the top of bundle page 4.
Yeah, thank you very much.
So, my Lord, I just read out the first 5 lines.
Yep.
And then at the end, he goes on, Lord Bingham's speech is consistent with the reasoning in Prudential. On the other hand, the other speech, especially Lord Minute, departs from the reasoning in Prudential and should not be followed. And having dealt with one or two other cases, if your lordships could go, and my lady could go over to page 417.
Sorry, where are you?
Paragraph 79.
79. Okay.
So here, Lord Reed summarises the discussion to that point, distinguishing between one, cases where claims are brought by a shareholder in respect of loss which he has suffered in that capacity, in the form of a diminution in share value or distributions, which is the consequence of the loss sustained by the company, in respect of which the company has a cause of action against the same wrongdoer. So that's the first category. And then secondly, cases where claims are brought, whether by a shareholder or anyone else, in respect of loss which does not fall within that description, but where the company has a right of action in respect of substantially the same loss. He then deals, my Lord, with cases of the first kind in paragraph 80 over to 83. He refers again in 82, as he's done previously in paragraphs 34 to 37, to the company's control over its own cause of action being compromised, and then emphasises in 83 a point which my Lord Justice Lewison has made a number of times in this hearing. The critical point is that the shareholder has not suffered a loss which is regarded by the law as separate and distinct from the company's loss, and therefore has no claim to recover it. And then he goes on to cases of the second kind in 84, paragraph 84, And he says one can take as an example cases where claims are brought in respect of a loss suffered in the capacity of a creditor of the company. So what Lord Reid then does, because that of course is what this case Marix was concerned with, he deals with the question of a creditor in 84, and similarly we can see in 85, halfway down, to the extent to which a company's loss may affect a creditor's recovery of his debt. He deals with double recovery as part of this analysis over the page at 87. And then he concludes, before going on to deal with the facts of the present case, he concludes at 89 on page 419, I would therefore reaffirm the approach adopted in Prudential and by Lord Bingham in Johnson, and depart from the reasoning in the other speeches in that case and in later authorities. It follows that Giles and Round and Gardner and Partner were wrongly decided. The rule in Prudential is limited to claims by shareholders that, as a result of actionable loss suffered by their company, the value of their shares or distributions they receive as shareholders has been diminished. Other claims, whether by shareholders or anyone else, should be dealt with in the ordinary way. So with all that, we submit is the conclusion of this very careful and detailed analysis of the majority in Lord Reid's judgment. It reflects Prudential, it reflects Lord Bingham in Johnson, and it is a straightforward, it's said, clear rule, the operation of which is dependent upon the shareholder's claim being a knock-on effect of damage to the company, and not a claim that it as a shareholder has suffered loss through a wrong done to it separately and independently. And then finally, my Lord Hodge's judgment, which is much shorter.
Critical bits, paragraphs 99 and 100, I think.
Yes, that's right. 99, the court's reasoning, which Lord Reid has quoted, has been criticised because of the stark assertion that the shareholder does not suffer any personal loss by the diminution in value of his shares or distributions. It cannot be taken at face value. Clearly the shareholder suffers economic loss. And because the example of a non-trading company whose only asset was a cash box is an oversimplification, the reason is nonetheless clear. Where the court asserts A, that the deceit on the shareholder causes the shareholder no loss which is separate and distinct, and B, when the shareholder acquires a share, he accepts the fact that investment follows the fortunes of the company. C, personal action would subvert the rule in Foss and Harbottle. What the court is saying, I agree with Lord Reid that what the court is saying, that where a company suffers a loss as a result of a wrongdoing, and that loss is reflected to some extent in a fall in the value of the shares or its distributions. The fall in the share value of the distributions is not a loss which the court recognises as being separate and distinct. That is the full extent of the principle of reflective loss which the Prudential case established. It's not articulate as a general principle to be applied in other contexts. It is a rule of company law arising from the nature of a shareholder's investment and participation in a limited company, excludes a shareholder's claim made in its capacity as a shareholder. Which in a sense brings the analysis full circle, because the whole point of the rule is that it relates to a claim of the company and damage to the company, which is the business of the company to be handled by the company's management and not the shareholder. And then finally, page 424, paragraph 108 of Lord Hodge's judgment. The characteristics of a shareholding as a means of participation in the company's enterprise, which are most directly relevant in this context, the context of this appeal, are the default rule of equality among shareholders and the postponement of shareholders' entitlements on a winding up of claims. Against this background, the law's refusal to recognise the diminution in value of a shareholder, the reduction of loss of distribution, which is the consequence of the company's suffering loss as a result of wrongdoing against it, as being separate and distinct from the company's loss, is a principal development of company law. It excludes the possibility of double recovery. It avoids a scramble between shareholders to establish their private claims against the wrongdoer in case the wrongdoer does not have sufficient accessible assets, thereby upholds the default position of equality among shareholders. And 2 lines down, he says it maintains the rights of the majority of shareholders, the Court of Appeal stated in Prudential, and it preserves the interests of the company's creditors by maintaining the priority of their claims over those of the shareholders in the event of a winding up. It may well be, as Lord Sales reasons, that the court achieves some protection of those interests by other means, such as case management and equitable subrogation. But the creation of a bright-line legal rule, as the Court of Appeal did in Prudential, its principle, that judgment has stood for almost 39 years. It was upheld in Johnson, and it has been adopted in common law countries. We should not depart from it now. And to be clear, and I hope I have made this clear, we're not asking you to depart from it, simply to apply it to the facts of this case. So, my lord, that's Marex. And then finally, in terms of the authorities, I was going to take the court to the Primeo case, which is at tab 18. My lord, this was another unusual case where the claim arose from funds invested by Primeo, the claimant, in the Madoff Ponzi scheme. The defendants, R1 and R2, were custodian and administrator in respect of the loss-making investments. Primeo's case was that if R1 and R2 had performed their duties as administrator and custodian, it would not have invested in the Ponzi scheme or would have redeemed its investments sooner.
Sorry, Mr. O, could you keep your voice up a bit?
I'm sorry. Yeah. In May 2007, Primeo restructured the investments in Madoff. And from that date, its investments were held through 2 feeder funds called Herald and Alpha. The question for the court was whether Primeo was barred by the reflected loss rule from claiming the loss of its investments in Madoff before May 2007, in view of the fact subsequently its investments were held through Herald and Alpha. So that was the issue the court was concerned with. And I can take the court to bundle page 576. And I know that the Court of Appeal will have appreciated that the members of the Privy Council were all also sitting as Supreme Court justices in Marex. And
Opinion was given by 2 of them in the minority.
yes, indeed, Lord Kitchen and Lord Sales, who give the advice here, are were indeed in the minority. And in paragraph 45, and we don't need to look at them in detail, the issues arising and the hearing in relation to reflected loss are set out by His Lordship in those 4 paragraphs. The first one was, what is the relevant time to determine whether the reflected loss rule applies, which is, as the court has seen, has been a matter of some discussion through the judgment of Lord Justice Flo in a different case, but is now established in the Allianz case and through this Privy Council judgment. And anyway, he said those are the questions which they were asking, and the analysis in which he deals with them starts on the next page, my lord, of paragraph 47. He says the starting point in consideration is the consideration of Lord Reed and Lord Hodge of the majority in Marex. He cites paragraph 9, which we rely upon, which I referred to the court earlier. 48, Lord Sale says, Lord Reid explained the reflective loss rule as one aspect of the rule in Foss and Harbottle. Lord Hodge explained the reflective loss rule in the same way. As set out by Lord Reid and Lord Hodge, the rule is a rule of substantive company law, not a principle for the avoidance of double recovery. And he then refers to paragraph 83 of Lord Reid's judgment, which we looked at, and at the end to paragraph 109 of Lord Hodge. And he then says in paragraph 49, paragraph 39, Lord Reid explained the reflective loss rule is derived from prudential in this way.
Can we just pause a moment, just step back from this? The claim by Promeo was, putting it simply as I can, I had money in my pocket. You, R1 and R2, were supposed to be advising me about how to invest it. You negligently, or whatever it is, told me to invest in this Madoff Ponzi scheme. I've no longer got the money in my pocket. That was the claim, wasn't it?
Yes.
And the company came in at a later stage. The rights had gone to the company, hadn't they?
Sorry, my lord.
I've forgotten the precise detail, but the corporate claim came in because the company had been interposed later.
Yes, the Herald.
Herald,
but the
yes.
claim, the main claim, is for what happened before the Herald transfer.
Before Herald and Alpha, yes, that's right. Then, just returning to the judgment, he cites paragraph 79, which we saw was the Lord Reid's concluding paragraph, and then comments after that the reference to the two types of case. In the this is a D on page 578. In the first type of case, the reflective loss rule applies and the shareholder is barred from seeking recovery for loss they may have suffered. In the second type of case, it has no application. The claimant can sue for loss they've suffered, even though they happen also to be a shareholder in a company which has a cause of action against the same wrongdoer. He then cites Lord Hodge from paragraph 98, which we saw, and then continues in paragraph 51. The present hearing is concerned with identifying where the boundary lies between these two types of case. It's helpful first to focus on Promeo's claim in respect of its direct investments. Promeo submits that its claims against R1 and R2 for losses in respect of its direct investments fall within the second category, and that the reflective loss rule has no application. R1 and R2 submit that Promeo's claim fall within the first category, and the judge in the Court of Appeal will therefore write to hold that Promeo is barred by reflected loss from recovery. In Marex, the Supreme Court was concerned to ensure that the reflected loss rule was kept within proper bounds and given limited scope. Lord Reid and Lord Hodge explain the ambit of the rule as limited to cases where a claimant suffers loss in its capacity as a shareholder in a company through a diminution in value of its shares in that company, i.e. through the mechanism of a wrong done to that company, which has a knock-on effect on the value of shares held by the shareholder. And he then refers to Foss and Harbottle and other paragraphs in Lord Reid's judgment in Marex. And then over the page, my lord, 579, paragraph 54, the principle, the knock-on effect principle, is then applied to the facts of the case. And we can see, if you could go down to 54, just above G.
It's in 53 that they make it clear that at the time the loss was suffered, Promeo was not a shareholder of Herald. It had taken money out of its pocket based on the faulty advice from R1 and R2 and invested it in this Ponzi scheme.
Yes. And of course, the timing point was the first point which the Privy Council were considering. Then 54, just above G, that loss was suffered by Promeo in its personal capacity and had nothing to do with Herald. It was not loss suffered by Promeo in its capacity as a shareholder, nor could it be said that it was merely the result of a loss suffered by Herald. that is a knock-on consequence of the wrong suffered by the company itself. So, my lord, we see, and that phraseology is repeated later in the judgment in relation to other losses. So we see that Privy Council in Promeo accepting this very limited and unique exception as Lord Reid has described it, and pinning this principle to a fact situation where the company has suffered loss and where the shareholder's complaint is that that loss to the company has caused his loss in terms of a diminution in the value of his shares. And my lord, in our submission, in any case where now, after Marix, far from this being the law having been clearly established for the purposes of all cases, the court has to apply the rule as described in Marix on the basis of the facts of each individual case. It is inevitable that that process, which is already underway, and one can see, for example, in the Allianz case that Mr. Justice Tier decided it one way, and shortly afterwards the Court of Appeal reversed him. There are all sorts of interesting issues which are bound to arise, which we say, as a matter of principle, should in each case be decided not on the basis of assumed facts, but where possible, following a trial where all the facts have been found. And indeed, there's a salutary example of resisting the temptation, as it were, of weighing in the judge, I won't go to it, but the judgment of Lady Justice Asplin in the British Investment Group and Smith case, where the question was raised there, is specific performance covered by the reflective loss rule, and where her ladyship said at the end of a short passage in her judgment, it's best left to a case in which it is essential to determine the issue. So the court doesn't, in our submission, and doesn't have to and shouldn't simply weigh in on assumed facts where it's not fair or safe to do so, excluding shareholders' claims, in circumstances where precisely the same point can be taken by the defendant at trial, as no doubt will be the case here, in relation to all these claims, where the judge, having had proper notice, she or he, can decide all the relevant facts so as to deal with all the many issues which this court had raised during this hearing about the facts as to what the company's claim would have been, for example, on a balance of probabilities, how a recovery by the company for loss of profits or one or other of these grounds would affect the position of the shareholders. And there are clearly, we would submit, many other factual issues which could and should, can and should be determined at trial. So, reflective loss, Lord Reid has now pinned the principle to the principle in prudential, which is a clearer, more precise description. But the reflection, my Lord, is a reflection of a claim by the company, loss to the company, which has had the knock-on effect of reducing the share value. That's it. That's what reflective means. It doesn't have any wider meaning than that. And it's clear as a matter of principle, I would submit, that from what we've seen from the Supreme Court and the Privy Council, the principle should be, as far as possible, limited and carefully confined, so that the same thing doesn't happen again, if I may put it like that, as happened with Johnson and Gore Wood, where what appeared to be a straightforward principle became hugely complex and the subject of numerous difficult cases and case laws that courts tried to grapple with what is a principle which can create serious unfairness to a claimant. And as Lord Bingham rightly said, where there is doubt, as at the very least there clearly is in the present case, I would submit, that ought to be resolved in favour of the claim at the strikeout stage. And the case ought to be allowed to go to trial where the facts can be properly determined. Now, the judge, as you know, rejected our submissions in applying facts to this case. I think it may be helpful to just go to the judgment, which is in the core bundle. Tab 5. Bundle page 81, the judge begins his discussion of the various issues.
Yes.
It's perhaps just, well, I would just note in passing, the law, before going to that at page 79 in paragraph 67, he records a submission from our, from first instance, that the reflective loss is a fiendishly complex area of law, and deals with those aspects, the conflict between nectarus and primeo, for example. And then the last 4 lines, he says, they say a decision on the application of reflective loss should only be conducted once the facts have been determined at trial and not in the context of a strikeout application. So there are a number of fact-sensitive issues in the present case which cannot be determined satisfactorily. So that submission was rectified, but he didn't deal with that in the judgment. He has dealt with the developing area of law point, which is at the passage I've just taken you to, 77.
Sorry, your point is he hasn't dealt with your submission that there's still uncertainty about the scope of the rule?
About the facts. It's the fact-sensitive point I don't think he's dealt with at all, as I read.
Oh, I see. Ah, right. Number of fact-sensitive issues which can't be determined satisfactorily. Right.
But certainly at 77, he goes on to deal with the question of whether it's a developing area of law and refers to the passages we'd relied on, for example, in Lord Brown-Wilkinson and Barrett. Then, my Lord, that in a sense, that the court can take this quickly, and the Court of Appeal is very experienced with dealing with developing areas of law. The point is a simple one, that where the law is complex and may be difficult to apply, and where it has changed and is changing, or has recently changed and been redefined as it has here, the court ought to be very careful before weighing in any particular case on the basis of assumed facts, because cases change and can change dramatically at trial, and it's far safer, as the courts have always recognised, to allow cases to go to trial where the difficult and changing area of law can be considered in the context of the facts at hand. It's in 81 that he says, although the claimants say initially this is a complex area of law, they then go on to submit that parts of the law that are relevant are uncontroversial or clear in their favour. They then refer to a formulation of the rule which is based on the judgment of the Court of Appeal in Prudential, rather than on the subsequent and now authoritative decision of the Supreme Court in Marix. An example of this arises out of the emphasis the claimants place on the use by Lord Reed in his judgment of the word merely, as in not merely a consequence, etc. And he says all 4 instances are simply a reference back to Prudential. With the greatest respect to the judge, I don't really understand this at all. It's quite clear from the passages I've shown you that Lord Reed is indeed reaffirming the position in Prudential. And to the extent that the word merely is an important part of that, and it may be in any particular case, he has reaffirmed that, and the Supreme Court had reaffirmed that that's part of the rule and should be applied.
Could you just explain how your client's loss arises otherwise than as a result of the wrong done to the company?
Well, my lord, putting aside the clause 12 point, which is different, our loss arises because as a result of the deceit, we contracted with them. And
Well, I know
not
that,
with
but how does it arise other than in consequence of the loss suffered by the company, which was also deceived, as you say? That's what you plead.
Well, my lord, the answer is, as in many of these cases, it may be. One doesn't know what the company's loss is because it's never made a claim. It isn't asserting a claim. It's never going to make a claim. And the position of the shareholder is that as in this case, I have a separate claim for loss. My claim is deceit. The loss is the value of the shares had I reached the agreement with the other party, not this one. And that entire claim has nothing to do with the company. And it's not an answer to it to say, well, the company may have some sort of a claim for damages which looks a bit like that claim. And if it brought it, it would be important for the court to protect the company by preventing the shareholder bringing this claim.
Can I just explore that a moment? Take the misrepresentations, which are said to be made to your clients and to the company. And it's then said that they were relied on. I think it said that they were relied on by both the company and your clients.
It does.
So, supposing, let's take it both ways. Supposing the company relied on them, then presumably it relied on them by choosing to contract with the AA rather than Solera. If, on the other hand, it didn't rely on them in that way, or didn't rely on them at all, then the company would nevertheless have gone ahead with contracting with the AA. And the fact that you might have relied on the representations in some different way has no significance because there wouldn't have been a contract with Solera. I mean, they're the same thing, expressed different ways, aren't they?
Well, my lord, no, in this important sense, that if that had happened and the company had proceeded with the AA, it would still be, my clients would still be perfectly entitled to say that had we not been deceived, we would have contracted with Solera, and had we done so, our shares would have been worth X. They're now worth Y in the light of what's actually happened.
But how could you have contracted with Solera if the company didn't?
Well, not in the same form, I agree, because the company was a party to the investment agreement. I mean, that's obviously right. But your lordship is envisaging, as it were, a situation where the company does one thing and the shareholder does another.
Well, I'm suggesting it's unreal, but suppose it isn't unreal. So the company chooses to contract with the AA. So the products that the company has go to the AA. Well, it's unreal to suggest that you could have done a deal separately with Solera when you didn't have the products to sell to Solera.
No, my lord, I see that. But nevertheless, the contract, the investment agreement or shareholders agreement is principally a contract between the investors in the company, namely my clients and the new investor, the AA. And of the straightforward case, I submitted straightforward that we wish to make a trial, is that we were deceived and suffered loss because had we gone with Solera, our shares would have been far more valuable.
I followed that, but then we are simply into the misrepresentation claim, where it seems to be impossible to envisage a circumstance in which you could have suffered loss, but the company wouldn't have done, because it all depends on whether or not there would have been a contract with Solera. So if you then move on to the breach of contract claim, at that stage the deal has been done with the AA.
Yes.
and I think you're saying at the moment, well, there might then have been contractual obligations to you that would not have been owed to the AA. I mean, supposing that to be the case, what would then have been the loss?
Well, I mean, put simply, our case is that you can ignore the company altogether. This is a straightforward, separate, distinct claim by a shareholder, which...
No, that's not right, Mr. Rold. It's not a question of whether it's a separate and distinct claim. It's a question of whether it's a separate and distinct loss, as Marix makes absolutely clear.
Yes, well, there are two elements, my lord, I agree. But the loss suffered, as we've accepted on this part of the claim, the not clause 12, the loss suffered in both contract and tort is the diminution in value of our shares.
Yeah.
We obviously accept that, and that's always been the case. And we're not seeking to say anything else. But that loss is not a knock-on effect of a damage done to the company. It's a direct result of the fact that we were lied to and relied upon it in concluding the investment agreement.
I mean, I think we're just going over the same ground, but it has to be, doesn't it? In the sense that on your thesis, your loss arises from the fact that the company did a deal with the AA rather than doing a deal with Solera. And so your loss is a knock-on effect of the fact that the company did a deal with the AA, not Solera. And that, on your case, the company has a claim in respect of, because it was deceived into contracting with the AA rather than Solera.
Well, in terms of the investment agreement, the claim is it's a knock-on effect of us doing a deal with.
So if we just separate out the investment agreement for a moment, by this stage, the deal has been done with the AA.
Oh yes, I'm sorry, Your Lordship's on contract. Yeah, I apologise.
Or you weren't making that point. So, but I mean, if you're worrying about, if we're concerned with the misrepresentation claim, either you contract with Solera or you contract with the AA. If the company contracts with the AA, then potentially it suffers loss. If you're right, it would be much better to go with Solera, but it's the same loss that you suffer.
Well, my lord, one goes back to the point, does it have to be exactly the same loss? But the company's claim would be that it had suffered loss of profits, income, however it was put. And that is not the same claim that the shareholders are making at all.
But
Shareholders' claim.
it's that loss of profit that rendered the company insolvent.
Yes, well, I mean, it's certainly part of what occurred in contract. There's a lot more to it than that.
So just coming on to the contractual claim. So for the contractual claim, we assume that the deal has been done with the AA. You can't go back to the Solera. You've done a deal with the AA. And we assume that there were contractual obligations owed to you, but not to the company. I mean, what would then be your loss?
Well,
It couldn't be that you would have been better off going with Solera because that past has been sold.
No, I mean, I accept in contract, Your Lordship's right, that the assumption is that it's gone ahead with the AA. They are now, we say, in breach of terms, obligations of good faith. Effectively, they've smashed up the business and bought it themselves instead of running it as they agreed to. So the claim is that our interest in our shares, the value of our shares is diminished as a result of their breaches of contract to us. And whether or not the company has a separate and distinct claim to recover loss of profits as a result of some of the same wrongdoing, that might be the case. But I mean, this is the sort of instance I would submit where, given that we do have a separate claim, a separate cause of action, and we say a separate loss on both claims, there may well a disparity between the two, or may well go, if one goes back to the box example, the judge will have to consider at trial if as your lordship put it to me, if the company had recovered something, what would it have recovered, and would that have rendered, would that within the reflective loss principle have the knock-on effect in terms of the share value?
But you've said in answer to my lord that share value is not the same loss as loss of profits.
No.
But your pleading quantifies the share value by reference to EBITDA, which is effectively loss of profits. I mean, it's a more sophisticated version, but yeah, that's what it comes down to. So it is the consequence of the company's loss in profit. It may, I suppose, affect the multiplier as well as the EBITDA, but one way and another, the foundation of your claim for loss in share value is the company's loss of profits, isn't it?
Well, it's certainly relevant. I accept it has to be because of the way that the amount's been calculated. But if we're right, as one can see from the figures, you do indeed apply a multiplier in favour of the shareholders to in valuing the shares, and it would be a high multiplier in a tech company like this, so that the relatively small loss of profit to the company is separate and distinct, and could in no way be regarded as somehow compensating the shareholder for a very, very much larger loss in the value of its shares as a result of its own course of action. And that's why we say that this is this aspect that your lordships have alighted on is another example where I would respectfully submit that all this needs to be dealt with carefully and on the evidence at trial, so that the judge can form a view as to the interrelationship, if there is one, between the two. I don't deny, my lord, that there is obviously interrelationship in a small company like this, where the loss of shares is obviously dependent on the loss of share value. It must be dependent on the company's performance. But, my lord, to shut out the claim at this stage on the basis of however this turned out, the judge could never be persuaded, which is really the test, that reflective loss was not a defence to the claim. In our submission, it's not the right way forward.
And in that regard, do you rely also on your alternative pleading at 1626A, which is the loss of a chance?
Yes.
And presumably, therefore, you'd say that is further removed from what might be.
Yes. Well, my lady, it is. Yes. So, across the claims, my lord, I've already dealt with the nature of the claims. I was just dealing with the judge's approach, which we got to in paragraph 77 of his judgment. Yes, I'm sorry, so he deals with the developing area of law point. Yeah. We saw in 81 dealt with the use of the word merely, to the extent that that's relevant, which I submit that it's not. And, my lords, to the extent that that is a key part of this appeal, namely whether this is a developing area of law, and all properly to be considered on the facts as found at trial, in my submission, the position is perfectly straightforward. It obviously is, as all the recent cases show. And that's an end of it, and assuming that we get over the arguability hurdle, the strikeout hurdle, on the main claims, it is an important consideration that cases of this sort, which are sufficiently arguable, should go to trial. That would be our submission. And he then goes on, my lord, in 83 to deal with reflected loss, and he breaks it down into 6 sub-paragraphs, which, Lord, I don't, with respect to him, accept that it's helpful to take a passage from Lord Reed's judgment and then put a gloss on it like this.
So you say there's a misdirection, do you, in 83?
Well, my lord, what the judge has entirely failed to reflect is the very point that we've seen over and over again in the cases, which is the knock-on point. I mean, this analysis simply doesn't deal with the fact that the rule only
Isn't that his
applies.
point 4? The loss is the consequence of loss sustained by the company. That's his knock-on point, I think.
Yes, I'm sorry, I hadn't read it in that way, but it seems rather broader than the way it's put in the cases. But anyway, my lord, that's how he decided to approach it.
Yeah, but do you say that's right or wrong? That's what I'm trying to get at. You say there's a misdirection in this paragraph.
Well, my lord, it's no, I don't. No, not in the sense that he has broken down what's in the main judgment. Save that, as we see it from what is elsewhere in this judgment, his analysis does not deal with the core of this, which is that is what I've called the knock-on point.
Yes.
He then goes on in 85 through to 88. We see the citation in 86, for example, from Prudential, which we looked at, which he says set out in 87. He says set out an important limitation. Lord Bingham makes clear shareholders may not recover a loss caused by a breach of duty owed to the company. It's not enough to say shareholders have their own independent cause of action. It's necessary to go and show the company has not suffered the same loss in respect of which it is entitled to make a claim. Well, in my submission, that isn't right. The question one's asking is whether the shareholder's loss is merely a knock-on consequence of something that's happened to the company. That's the test.
Is there a point of substance between you there? I mean, what the judge is saying is you have to have your own course of action and you have to have your own loss. And that's right, isn't it?
Well, my lord, at paragraph, trying to find the right part of the judgment. He says in 88, in the present case, the misrepresentation claim is that without the misrepresentations, the company would have been much more valuable and would not have failed. The claimant's alleged losses are entirely derived from the claimed losses of the company. Well, my lord, with respect, as I've just discussed in submission with this court, that's not right. To the extent that that's being applied as the test, it's not right to say that they're entirely derived. It's a different claim and gives rise to a different loss.
I know we're at risk of just going over the old ground again, but focusing here as the judge is on the misrepresentation claim, why aren't your losses derived from the losses of the company in the sense that the company has contracted with the AA, not Solera, in reliance on the same misrepresentations? And that's what's brought about Motoriety's downfall.
Well, my lord, as I think I've accepted, and I've fairly accepted, the position of the company's finances is obviously relevant to the calculation of our claim. I don't dispute that, because the valuation of the shareholding must to some extent be dependent on the position of the company. But the loss is not the same loss. It's a calculation of what would have happened had we done the deal with Solera and not with the AA.
But why isn't that loss, which is a loss in share value, simply reflective of the loss which the company has suffered by contracting with the AA, not Solera? What separate loss is there?
Do you want an hour to think about that, Mr.
Yes, okay, yes. Oh, sorry, I hadn't noticed the time. Yeah, of course, yes.
All right, we'll start again at 2 o'clock. And I think I'm right in saying, unless I've missed it, that paragraph 88 is the only paragraph in the judgment where the judge analyses what he calls the original claims, that is the misrepresentation.
I
And
think
the
it is,
contract.
yes.
Yeah, 2 o'clock.